Settling is always preferred, and there's several reasons for that. One of them being the parties know their positions and the details of their case more than anybody else. The parties know what they want more than anybody else out there. And when I'm talking to a party and where everybody wants to go to trial, everybody wants to fight. We want that day in court in front of the judge. And what they don't understand is that judges are people. It's a lawyer up on a stand that has a lot of authority, and they're only going to hear your case 3 hours, maybe a day, and then they're going to make a decision that's going to affect the rest of their lives. It's been quoted many times. The judge I spoke with yesterday even mentioned it, is that parties have a much higher probability of sticking to agreements that they come to themselves. Because they've agreed to it, they understand the dynamics of their situation much better than an attorney can explain or a judge can understand. It's better for the parties, it's better for the children, just all the way around, particularly from a financial aspect. If you can end your case by agreeing to it, understand, even if you go in front of a judge, you're not likely to get every single thing you want. Very rarely are cases so cut and dry that one side is wholly right and the other side is wholly wrong. And where clients dig themselves into holes often is pushing to trial, because the vast amount of monies incurred and billed are into trial prep. Mediation is an excellent tool. So I really push parties to do that, settle at mediation, and at least talk on your own. You don't have to have the attorney involved, you don't have to be at a judge, you don't have to be in front of a mediator at an official setting. I understand some relationships won't permit that. Some parties have issues that makes communicating between themselves without third parties almost impossible because of whatever reason. But most people can. And if you could just sit down with your spouse, agree to what you can do, it'll save you a ton of time and money. And what you've agreed to, statistically speaking, so I've heard, you're more likely to adhere to that on both sides. Because everybody, they know what they have to do, but they really want the other side to comply as well. They want you to stick to the agreement. It is in 99% of the cases, and again, we're a full service firm, so I don't necessarily want to speak to every area of law in every single situation. But in the vast majority of lawsuits, from contracts to family law to whatever really it is that you're fighting about, it is 99% more suggested or more pushed that you settle it yourself. Not I say with yourself, but you come to an agreement under the guidance of an attorney with the other side. Many people, of course, this is why we're here, they don't understand their rights, they don't understand their law. That's our job. But once we advise them, talk to them, we explain their strengths, and sometimes I get pushback from clients in some instances where they say, who are you representing? You're supposed to be, pushing for me. It's also my obligation to inform you of the weaknesses of your case as well. So I try to give them a full view of, this is your strong points, this is your weak points, this is what I think the outcome may be if we proceed. I think this is optimistic, I think this is what you'll end up getting, and that's how we begin going back and forth. Mediation brings the parties into a more formal environment. It's not nearly as informal as a courtroom, but they're usually at a courthouse or a business office. There's another individual there that's supposed to be unbiased and help the parties along. You have both attorneys present. Usually you don't have to mediate with an attorney, but it's highly suggested. And that's the party's chance. And really we have to always remember, that what we have to overcome and what they're always in their mind is, will I get a better deal at trial? Am I going to come out on, better at trial? And that's always a gamble. It's always a gamble, because you just never know how the judge is going to feel that day, what the judge is going to decide that day, how your case is going to present. I mean, you can prepare as well as you can and as much as you can, but it's very difficult to accurately predict an exact outcome of a case if you go to trial.